Yeah, I'd like to talk about the death penalty because this is the one when people find out I'm a criminal defense attorney. This is the one thing they like to talk about probably more than anything else, and because that's the death. That's because the death penalty is the ultimate penalty. It's the ultimate case, and I have handled several death penalty cases over the years that I've been practicing as an attorney. There's the state death penalty and the federal death penalty, and we'll talk about the federal death penalty in another um, presentation. But I'd like to kind of focus on the state death penalty in the state of Florida. And I guess we can start in the early 1970s when, for a period of time, in a short period of time, the death penalty was held to be unconstitutional by the United States Supreme Court because there was too much discrepancies, that there wasn't enough, uh, there wasn't an objective system for imposing the death penalty. And so it was found to be a violation basically of equal protection and due process. So what happened is the states started coming up with death penalty statutes that they believed would comply with the Supreme Court requirements. And in Florida, we have what is really a two-phase process in the death penalty case. And the whole idea in Florida and in the rest of the states, and based on what the Supreme Court has required, is that the death penalty is saved for the worst of the worst. And that, in effect, means that it's limited, especially in Florida, to murder cases, to first degree premeditated murder cases. So the way it works is the death penalty trial is really two trials. There's a guilt phase and then there's a penalty phase. And the guilt phase is the first part of the trial, and that's where the state of Florida has to prove that somebody is guilty of murder beyond a reasonable doubt. They have to prove that the defendant on trial committed premeditated murder beyond a reasonable doubt. And if you have factual defenses to the murder charge, that's when you can try to present those, and you can try to have a jury acquit your client of first degree murder, and or find your client guilty of a lesser charge such as second degree murder or manslaughter. And if that happens, the trial is basically over. There is no penalty phase because the judge will, if it's a first degree murder charge, the only two possible sentences are life and the death penalty, life in prison or the death penalty. If you're found guilty of second or degree murder or manslaughter or a lesser charge, there is no death penalty. It's just a question of what your sentence ends up being. For second degree murder, the maximum is life. For manslaughter, the maximum is 15 years or 30 years if a firearm is involved or if you have some kind of enhancement based on prior record. But a lot of times you have to use strategy to determine whether or not you're going to put up a strong defense during the first phase. Because to be quite honest, most of these death penalty cases are cases in which the evidence is overwhelming that somebody committed a murder. Then the question becomes what degree of murder it was or what the proper sentence is, whether it should be life in prison or the death penalty. So a lot of times, if you're just trying to save somebody's life, you're not going to really contest a lot of the facts during that first guilt phase. But at any rate, if a jury finds somebody guilty of first degree murder beyond a reasonable doubt, then you move on to the penalty phase. And that is when the same jury that heard the evidence during the guilt phase will decide whether or not the person that they've convicted of first degree murder should receive the death penalty. And the way the system is set up now and the way the Supreme Court required it is there have to be what they call aggravating factors, which make this first degree murder conviction so out of the realm of ordinary first degree murder convictions that the appropriate penalty is death. It's the only penalty that's appropriate. The aggravating factors would include heightened premeditation, that would be like laying in wait to kill somebody, or killing somebody for insurance money, that sort of thing, which what you would the layman's term would just be cold-blooded murder with no conscience or anything like that. And then there's also what they call heinous, atrocious, and cruel. That's another aggravating factor, and that's kind of like a torture murder. And there's others that we could go into if we had more time. And I think there's a total of about 8 to 10. Law enforcement officers, children, those are considered to be aggravating factors as well. The defense has a chance during this penalty phase to put on what they call mitigating evidence. And the law does not restrict what the defense can put on as mitigating evidence. The defense can put on any evidence they feel is appropriate in order to save their client's life, basically. The aggravating factors are limited. I forgot to mention that. They're limited to the factors that are put out in the statute. But the mitigating factors are not limited. And so basically, you put on any evidence that you feel would warrant the jury giving your client a lesser sentence other than death. And there are many different things that you can do. You can bring in my opinion, the two best witnesses, the two best approaches that I've seen in death penalty cases are the mother of the defendant being called as a witness, and then appealing to Jesus, basically, religious arguments. Those are the two most effective arguments, I think, during a death phase or a penalty phase in a first-degree murder trial. But what has happened over the years is that the people that are eligible for the death penalty, the groups of people that are eligible for the death penalty, have been just kind of whittled down. Like I said, the worst of the worst. But the courts, the Supreme Court in particular, over the years have made it more and more difficult to impose the death penalty because of many of the concerns that people voice, such as innocent people being convicted of murder. And, there are a lot of cases where innocent people have been released from death row because evidence has come forward after many years showing that they were innocent. And you have to wonder if any of these innocent people have actually been executed because of the death penalty. The Supreme Court recently held that the death penalty cannot be applied to juveniles, once again restricting it. They've also held that the death penalty cannot be applied to people with low IQs, once again narrowing that group of people eligible for the death penalty down. I think the long-term consequences of all these arguments and all the litigation over the years and as society moves forward and becomes more progressive in certain ways, I think eventually the death penalty is going to be abolished in this country, as it has been in most of the Western world. There are very few countries in the world now, at least in what we call the Western world, that still have the death penalty on the books. Hardly any countries in Europe. I don't think there are any. And in fact, Mexico has abolished the death penalty. I think most South American countries have abolished it. And so the United States is being kind of put into a group of countries that aren't the greatest kind of group of countries to be grouped with. Countries, like I guess China has a lot of death penalty cases, Saudi Arabia, some of the countries that we often criticize their legal systems, but it's hard to criticize their legal systems when we have the same penalties that they do. So, in my opinion, the long-term trend is towards eliminating the death penalty. And I don't know if that's going to happen in my lifetime, but I think eventually it will be eliminated in this country.